for generations. A complementary training course went hand in hand with the delivery of a newly purchased firearm, because safety is the first priority to my client. This training course was gratefully accepted by Ms. Harrow because she knew just how dangerous firearms are. Opposing counsel and Ms. Harrow have brought claim of negligence against my client for the retention of the safety instructor assigned to Ms. Harrow on the 28th of May 2022. Opposing counsel have said that they will present a litany of evidence to satisfy their burden of proof. Opposing counsel will attempt to portray Ms. Cantrell as an incompetent safety instructor. Opposing counsel previously said that a gun should not have been entrusted to Ms. Cantrell. However, the Imperial Department of Justice says otherwise. Countless hours of training says otherwise. 9 months of successful training courses says otherwise. Expert witness Jackie Staub will say otherwise. We will also prove to you today that Ms. Carbo knew the risk. And I wish to take you through each of these points. Firstly, you will hear that Ms. Carbo knew the risk. You will hear this time and time again from both words and actions of Ms. Carbo. Most importantly, you will hear this from Carbo herself, who will say, "I'm sure of it, she is aware just how dangerous firearms are." Before proceeding with full ownership of the firearm, and even before attending the complementary training course, Ms. Carbo will confirm that she was presented with a liability waiver to read and sign that told her just how dangerous firearms are. The evidence will show that Ms. Carbo knew the risk, and despite knowing this information, was happy to proceed with the safety course under the guidance of my client. Members of the jury, we will prove to you here today that Ms. Carbo knew the risk and that Ms. Drew Cantrell is not negligently hired. That is why, at the end of today's trial, my co-counsel, Ms. Anna Doherty, will stand before you and ask for the only just verdict. Find against Ms. Carbo's motion. Thank you.
Plaintiff, please call your first witness.
Yes, Your Honor, it's time to place the calls of Justice Carbo. Stand.
One moment, sorry, I forgot to check when you guys are ready to proceed. I'm so sorry. We can take a minute if you have time. We'll take one. Okay.
May I proceed, Your Honor?
Yeah, I think are we good? Okay, you may proceed.
Good morning. Could you please introduce yourself to the court?
Hello, my name is Justice Carbo, and I live in Imperial, West Pacific.
How long have you lived in Imperial, Ms. Carbo?
My entire life.
What do you do for a living?
I'm a medical student.
Why are you here in court today, Ms. Carbo?
I'm here today because I was shocked at shooting star gun.
Why were you at shooting star gun range in the first place, Ms. Carbo?
I went to purchase a gun.
Why did you feel you needed to purchase a gun, Ms. Carbo?
In my recent years, I have gotten my cargo 3 times and gotten blocked. It reached an extent where I completely no longer felt safe.
What made you choose Shooting Star as the establishment to buy your gun from?
Well, Shooting Star has a good word from it, and they have quite a few commercials going on. That will sure that's bigger.
Did you ever reach out to anyone from Shooting Star about your interest in buying a gun?
Yes, I reached out to the owner, Scott Coleman, prior to the
When you did go into that shop, what did the two of you discuss?
We discussed how I would be complete gun novice, and I had no experience with guns, and I have several issues.
And what were these questions?
I have questions on how to properly store a gun, where to use it, and how to safely.
Did Ms. Coleman ever talk about how to safely use a gun further?
Ms. Coleman chuckled at the idea of me being a gun safety course and believed that it was not true, but they could throw something together.
Did Ms. Coleman ever manage to throw something together for you?
Eventually, we agreed that I would return in roughly 2 weeks so I could take a gun safety.
And did you end up going in 2 weeks?
Yes, I returned 2 weeks later, roughly on May 28th.
And what were your first steps you went through when you decided to buy a gun that day?
Well, Coleman had me fill out some.
After this paperwork, what did you do?
After that, Coleman introduced me to my safety instructor, Drew Cantrell.
How did Ms. Cantrell teach your safety course?
Ms. Cantrell took me to the back stall of number 11, where I would also be taking the safety course with a Nick.
Did you recognize a photo of stall 11 where the three of you were standing?
Yes, I would.
Your Honor, at this time, may I approach the witness who put up the pre-marked exhibit 2G?
You may.
Ms. Carr, was this a fair and accurate copy of where the three of you were standing with X's marking each spot?
Yes, it is.
Your Honor, at this time, the plaintiff submits exhibit 2G in evidence.
Any objection?
No objection.
So entered.
Ms. Carville, after you were taken to stall 11, how did Drew Cantrell continue the safety course?
Cantrell went over some basic rules and continued by showing how to aim.
And how did Drew Cantrell specifically teach you how to aim a gun?
Drew Cantrell told us exactly where to stand, and after that demonstrated by taking the first shot.
What happened after Ms. Cantrell took that first shot?
After Miss Cantrell took that first shot, I felt a clincher twitch in my left arm, to which then the gun was pointing downward at my leg where I was shot. Right after that, my leg was completely numb.
Ms. Carville, what happened after you were shot?
After I was shot, I was bleeding so much that they had to take me to the ambulance. And from there, due to my wound, I had to receive major correctional surgery.
Thank you, Ms. Carville. Your Honor, no further questions at this time.
Cross.
Before I begin, I just apologize for my voice. I'm something on this class.
Thank you, no worries. Do what's comfortable for you.
So good morning, Ms. Carter. You went to in-person meetings with Ms. Carter going on, is correct?
Yes, I had many questions, even after the
And you purchased your phone at the end of the second meeting, is this correct?
yes,
And in the in-person meetings, Coleman was quite thorough in explaining the ins and outs of finding this phone, is this correct?
yes, again, I have many questions because I was already done on.
And in store, you spoke about how to safely store a gun, is this correct?
Yes, again, another question that I had.
You spoke about how to safely handle a gun, correct?
Yes,
You filled out government forms, is this correct?
yes, Coleman told me that they were necessary for that.
And you signed the liability waiver, is this correct?
Yes, but never did I imagine that the liability waiver would actually meet.
Your Honor, can you then get a liability waiver difference?
Sure.
Any questions? No.
Ms. Carter, could he draw your attention to the second paragraph in this letter?
Objection, Your Honor? Is this, I do not know if opposing counsel is submitting this into evidence, and I would request that they submit to the evidence before asking Ms. Carville any questions about this today.
Apologies, can I evidence of evidence?
Why don't you lay a little foundation to be sure that she's familiar with the document, she knows what it is, and then you can offer it in depth.
Of course, so it's here, the liability waiver that Ms. Carbo would find, and it outlines the risk involved in crossing the threshold and distinguishing the
Objection, Your Honor, attorney testifying.
Why don't you ask her a few questions, to know whether she is familiar with it, if she read it, if she signed it, just to be sure that she is familiar with this document, and then let's sit down.
So, this is the liability waiver you signed, correct?
Yes, the one that I was required to sign.
And you recognize it as the.
Yes, again, Coleman required me to sign it, right?
And this is.
Yes,
So can I direct your attention to the second paragraph,
Is it submitted to evidence? Objection, Your Honor, is this submitted to evidence?
as I previously asked, and it's being submitted to them.
Any objection?
Yes, Your Honor, hearsay.
Your response?
And this here is not hearsay, I believe, it's just outlining what the witness did on the day.
Your response? Reply?
As Ms. Carbo did sign that waiver and what the waiver is depicting, it is being offered for the truth of the matter and it is an out of court statement and therefore it is hearsay.
Are there any exceptions that this document would fall under to not be deemed hearsay?
I'm only using this document to outline that Ms. Carbo knew the risks.
So as long as you're only using it for her to understand what the risks are, that will be permitted, but anything regarding the actual content of it will be deemed hearsay. So stated and overruled in part.
So again, second paragraph, I'm fully aware of risk and habits connected with the non-premises. Did I read that correctly?
Objection, Your Honor, hearsay.
I'm going to sustain.
So now it comes to talk about your training course, something. So you were dissatisfied that the training course was thrown together, is this correct? You say you were dissatisfied that this training course was thrown together, is this correct?
yes. Well, clearly I was dissatisfied, seeing as I ended up shocked by the end of my stay.
Your Honor, can I ask for some exhibit 18 intelligence,
Which one is 18?
text messages, inside of all my.
Objection, Your Honor. Tax foundation.
Yeah, why don't you, again, if you're gonna emit these text messages, and why don't we have a little foundation laid to be sure that these text messages, she's familiar with it, they were text messages of hers, et cetera, before we enter it into evidence.
Okay, so would you please turn to exhibit 18? So these here are text messages between you and Angela, kind of to confirm this. Yeah, there. Can I direct attention to the second that?
Objection, Your Honor, is it submitted as evidence?
The request of the program can speak to this.
I think we need a little more foundation laid, before I can see whether this is in evidence. So let's make sure she's familiar with these text messages, she knows who they're from. Just that the cursory review doesn't have any names, so let's see what she knows about these text messages first.
Okay. So in the second message, both bus stories are looking along the city state gate. Is this correct? Yeah.
Yes.
And so can we infer from these messages that Coleman and Cantrell had organized this training for months?
Objection, Your Honor. This is outside the scope of this witness's knowledge.
Sustained.
So during this training course, you were informed of basic governance, is this correct?
Yes, Coleman spoke over basic, federal prior to, shooting.
And you were shown how to code properly, is this correct?
Yes, again, part of the same.
So Drew Cantrell advocated extending it, is this correct?
At the time being, that was my understanding.
And finally, at the beginning of this trial, we heard that this case is all about money, and that's correct, isn't it?
Objection, Your Honor. Witnesses are constructively sequestered and therefore Ms. Carver would not have heard that.
Are they sequestered except your party representative, correct?
I do not believe we established party representatives, but if you would like to reform that both party representatives are not constructively sequestered, we can establish that, yes.
Did you intend for your party representatives to be present in the courtroom? Like this? No. Defense?
Yes.
We will have the plaintiff, I guess, be constructively sequestered since there was no intention of her being in the courtroom. Your representative may be present, not sequestered.
Yes. Sorry, Ms.
So because you are here, I'm not going to take every single penny, so please start with that.
Objection, Your Honor. I just established that the witness was constructively sequestered and they received feedback and examination.
I'm asking for the witnesses statement.
The witness's prior statement or what was said in the as long as it's the witness's prior statement, that will be permitted, but nothing regarding opening statements. No, what
You were here to say every penny didn't start.
It's the least that I can do because of all the emotional and physical trauma that I had to endure with the shooting star. I would never want anyone else to ever have to go through what I did.
Ms. Carver, you are here to every penny. Correct?
Yes,
Objection, Your Honor.
Thank you, no further questions.
Your grounds for objection.
This is more prejudicial than probative as the phrasing of here's the every single penny would have a prejudicial effect on the jury with Ms. Carbo's intentions in this trial.
I'm simply quoting what was said in the
Your Honor, that does not make a difference as whether or not this is prejudicial or probative. The way that counsel phrased the question is very prejudicial to the jury because it phrases Ms. Carbo as money hungry, one might say.
I don't think this is prejudicial at this block said by the witness.
There's no probative value here, Your Honor.
I'm going to overrule objection. The testimony will stand. The jury will infer as to what they would like from that testimony. I don't find it being substantially prejudicial and more probative. So the testimony will remain. Overruled. Redirect? No redirect. The witness may be excused. Plaintiff may call their second witness.
Yes, Your Honor. The plaintiff called Roscoe Hernandez to the stand.
Just give 1 moment.
Yeah.
To make sure everyone is caught up. My fatal flaw here. There's your guy. All set? You may proceed.
Good evening. Would you please introduce yourself to the court?
Yes, my name is Ross Hernandez. I am the owner of a small business down here in West Pascal, Marion, where I was born and raised. It's a flower shop called Pascal Pedal.
Now, Mr. Hernandez, have you ever been to the Shooting Star Gun Club?
Yes, Shooting Star Gun Club is located in the same strip mall that my flower shop is. And I go there around 4 times a week during my lunch breaks or things such as that.
And what do you do while you're at Shooting Star?
Typically, I go to Shooter McTaverns, which is a joint business with the Shooting Star Gun Club, a bar and a cafe. I like to hang out with my best buds and grand old time chopping it up.
Well, you mentioned you frequent Shooting Star. Do you know Skylar Coleman?
Yes, Skylar Coleman's the head honcho, boss over there at the Shooting Star Gun Club.
And how do you know Miss Skylar Coleman?
Well, as a fellow business owner myself, I went to Skylar Coleman for advice when it comes to how to run a business, what motivates them to run their business, things such as that.
And what would she say when you two would have this conversation?
Well, Miss Skylar Coleman, when I asked her about what motivates her, I can have a response to that.
Well, what would she say when you asked what motivated her?
Miss Skylar Coleman said, "I'm just looking to put a firearm in the
Objection, Your Honor.
every."
Hearsay.
Your Honor, may I be heard? This witness is referring to Miss Skylar Coleman, who is the party opponent for Shooting Star Gun Club, which means this falls under Rule 801D2, which is the hearsay objection for a party opponent.
Response?
And this witness, there is no proof that my client said this statement, and therefore I think it's fair for it to be heard by the court.
Your Honor, this witness is under oath, and if counsel would like to, on cross-examination, determine whether or not this witness is telling the truth, then they can do so. But this does fall under the hearsay of exception 801(d)(2) for a party opponent, which means it can be allowed in today's trial.
Based on the rule of evidence, I'm going to overrule as long as the witness stays to through Cantrell's testimony, it will be admitted as non-hearsay under that rule.
Yes, Your Honor. I'll re-ask the question. What did Ms. Coleman say when you asked what motivated her?
Ms. Coleman said, I'm just looking to put a firearm in the hands of every Empyrean citizen.
I see. Now, I want to talk a little bit about the shooting star gun club itself. Do you know Drew Cantrell?
Yes, Drew Cantrell, that's an employee, shooting instructor to be specific, over there at, the Shooting Star Gun Club.
And do you see her around Shooting Star when you attend?
Yes, I've seen Drew Cantrell around the Shooting Star Gun Club when I go there. I've seen them shoot around 2 or 3 times.
And what would you see when she was shooting star?
Well, I would see Miss Cantrell shoot, and what I wouldn't see is a bullet hit the target. I'm talking that bullet went to the right of that target, sometimes hitting the target in the stall next to it. I'm just saying, like, oh my Lord, you can tell me.
Now, were there any other times you saw Miss Cantrell handling guns?
Yes, 2 times. I can think of and recollect off the top of my head.
Well, let's talk about that first time. Or when did it occur?
First time was in 2021 during the month of May.
And what happened, Mr. Fernandez?
Well, what happened was, I witnessed, kind of, well, before that, I witnessed Drew Cantrell. After me bugging some other employee at the gun club, which prompted me to be there in some type of argument. With that witness, Drew Cantrell lit a firearm in her hand and pointed at that other employee.
Was Miss Skylar Coleman there?
Miss Skylar Coleman was indubitably there.
And after you saw Miss Cantrell point a gun at another employee, what did Miss Coleman do?
Skylar Coleman, after witnessing what I just explained, raised her voice louder than I have ever heard her voice go. And then, after raising her voice as loud as she did, proceeded to give Miss Cantrell a verbal warning.
I see. Now let's talk about that second incident. When did that occur?
The second incident, well, that was the same year, 2021, in November.
And what happened?
Well, I was only non-employee in the shop at the time, and looking for Skylar Coleman, you know, I wanted to show her my new Lego set. And I ended up coming across the cracked open office door, to which I heard Skylar Coleman giving a lecture about a loaded gun being brought from the gun range to the front office counter.
Did you tell who Miss Coleman was talking to?
Well, what I heard was Drew Cantrell's name all throughout that lecture.
Thank you, Mr. Fernandez. Thank you, Your Honor. No further questions at this time.
Shots whenever you're ready.
Good afternoon, Mr. Fernandez.
Good afternoon.
And you would consider yourself a close friend with Ms. Coleman, is that correct?
Yes, I went to Ms. Skylar Coleman with advice and questions.
And
So-
do you know, do you think that Scarlett Coleman runs Shooting Star was?
I believe that Ms. Skylar Coleman has good business strategies, which is, you know, why it's so tragic that such event on May 28th would take place.
Thank you. Now, you know Drew Cantrell, correct?
Yes, I do know.
Mr. Fernandez, you've never liked Drew Cantrell, is that correct?
We have most definitely had our differences.
You called him arrogant, correct?
I have seen, arrogant qualities in that character.
Mr. Fernandez, back to my question, have you called?
Your Honor, that objection gathering the witness, counsel has asked, Mr. Hernandez a question and is simply trying to answer and counsel's not letting him get his answer out.
Counsel, this is cross-examination, just a right to control the witness. So unless it gets aggressive in any form, I will instruct you to let the witness finish, but you may control the witness anyway. Overall.
And then you called them, called you contact as well, is that correct?
Yes,
And you testified about 2 instances involving group contact prior to May 28, 2022.
the listeners,
Yes, are these the only 2 you're aware of?
off the top of my head, yes.
Did you witness both of these incidents?
I saw one with my eyes, heard another with my ears. Those are 2 senses that I value.
So, did you witness both of these incidents with your eyes?
Not with my eyes. My eyes were active during the second one, but the main source of information inside of my mind was through my ears.
Okay, thank you. And is it correct to say you've never seen an incident with Drew Cantrell inside the gun range? Is that correct?
What do you mean by incident?
Have you ever seen him act unsafe in the gun range?
Besides that atrocious shot.
You've never seen him act inside the gun range?
No.
Thank you. And just to remind the members of the jury, you describe yourself as a gun novice, is that correct?
I have definitely described myself as a novice.
Yes. So how do you know Drew Cantrell has a terrible shot?
Because I did not see the shot, the bullet that they shot hit the target in the time that I did see Ms. Cantrell shoot.
Sorry, just to clarify, and you have minimum gun knowledge, correct?
Objection, Your Honor, asked and answered. Counsel has already asked Mr. Hernandez numerous times when they were gun novice and is now asking them for a third. This question has been answered numerous times by the judge.
Here,
Sure.
I have moved on from the fact that he's a gun novice. I'm asking now about his knowledge, sorry, I can't remember the word. With guns, his knowledge with regards to guns.
Your Honor, for somebody to be a gun novice means that they don't use or have knowledge of guns. Not only has this witness established it on direct examination, but they've now established it numerous times during this cross-examination period.
Sorry, I was just trying to clarify for the benefit of the jury and court.
This is cross, so I'll allow a little leeway, but in terms of, I think we all gathered that he is a novice, and you can go a little into his knowledge, but I do agree that being a novice would have a lack of knowledge, so I'll give you a little leeway, but, after that, we should move on.
Thank you. So my client, Drew Cantrell, has a lifetime of gun knowledge and 9 months of professional experience.
Objection, Your Honor, out of the scope of this witness would have no way of knowing that, Ms. Cantrell has, 9 months of a year or 10 years or 2 days of experience and has not testified to these things, nor have they said during this cross-examination period that they have any knowledge of how long, Ms. Cantrell has been using guns.
I haven't yet gotten to my question, Your Honor, I was just making a statement to my question.
Well, then, Your Honor, this witness is this attorney is testifying, during the cross-examination period, but still, the topic of the question is something that is out of the scope for this witness.
Go ahead.
I don't think that my question is out of the scope, if I would just be allowed to ask it.
If you could lay a little foundation maybe as to how he knows whether Drew Cantrell has had experience or not, just to make sure that he is familiar and has that knowledge, personally has that knowledge.
So you say you've been going to shooting cabins for years, yes?
Yeah, 4 times a week. I love the latte.
And do you know how long Drew Cantrell has been working there?
Objection, Your Honor.
I'm just trying to lay foundation and previously you have to be honest.
Overall,
You know how long Drew Cantrell has been working there?
No.
Now, with Scarlett Coleman in the shop, the time of the first incident, 8:20.
Skylar Coleman was there.
Sorry, surprised you disagree that Ms. Coleman said in her deposition that she was not. in the-
Objection, Your Honor. This attorney cannot ask questions about somebody else's deposition or what this witness would be surprised by. They do not know about any separate depositions nor whether, and then so this attorney cannot ask any questions regarding somebody else's deposition.
Unless you can lay foundation for a reason that this witness would have knowledge about another witness's deposition testimony, I'm gonna sustain.
And could I just clarify that these witnesses have said that Ms. Coleman was in the shop? However,
Yes, I believe that testimony is still on record that Ms. Coleman, he was aware that Ms. Coleman was in the shop on that 2021 incident.
thank you. Just one final thing, Justice Hernandez.
Alright,
You say in your affidavit you saw Drew Cantrell shooting 2 times within the 9 months that you've been an instructor. You clarify how many times with you?
2 or 3.
Thank you. And you say she always has a terrible shot, correct?
Despicable, atrocious, horrendous job.
So 100% of the 2 or 3 times that you've seen out of 9 months of instruction, is that factually correct?
Actually, well, it is a truth that I hold deep inside of my dear old heart.
So you would consider that factually correct?
Yes.
Thank you, Mr. Hernandez. Nothing further, Your Honor.
Any redirect?
No, Your Honor.
You may be excused. How's the jury doing? Good, all right. Plaintiffs, call your next witness.
Yes, Your Honor. The plaintiff calls Dr. Jordan Judd to the stand. Good morning, Dr. Judd. Can you please introduce yourself to the court?
Good morning. My name is Morgan Judd, and I'm an associate professor in the Center for Gun Violence Prevention at Marion State.
And what is your educational background?
I have a PhD in public policy from Tulane University, as well as a master's in statistics from Oxford.
How, and what is your experience with firearms?
Well, before I started working in education, I spent over a decade working as an investigator in the Bureau of Alcohol, Tobacco, Firearms, and Explosives, also known as PATF. I received extensive personal training in firearms, as well as I hold a firearm safety certificate from the Imperial Department.
But the record reflects that according to stipulation 12, Dr. Judd's methods in the field of firearm safety and public policy are reliable. The plaintiff would like to tender Dr. Judd in the field of firearm safety.
Any objection?
No objection.
Now, Dr. Judd, how are you involved in today's case?
Well, I was made by counsel for Justice Cargo to conduct a comprehensive analysis and provide my professional insights on today's case. With respect to the accident, I was asked to focus on 3 main aspects. Number 1, describing best practices for firearm safety. 2, determining what, if any, best practices for firearm safety were violated by the Start Gun Club. And 3, determining if these safety violations contributed to the shooting of Justice Cargo.
Were you asked to apply your expertise to any other issues?
I was also asked to analyze the Imperial Responsible Firearms Sales Practice Act and its relation to shooting stars entrustment of a gun to Drew Cantrell or their sale of a gun to Justice Cargo.
And what material did you review in your house?
I reviewed the depositions of Justice Carbo and Skylar Coleman, as well as the affidavits of Nick Allred, Aiden Line, and Drew Cantrell. I also reviewed what's been marked as Exhibit 1.
And I want to move on to the first part of your analysis, the best practices for firearm safety. Would a visual demonstrative help you in your analysis?
As I prepared one for today.
Permission for Dr. Judd, permission to publish the demonstrative.
Any objection?
No objection.
You may publish.
And permission for Dr. Judd to make use of the demonstrative.
Yeah, so you having her step down or? Yeah. Sure, she can step down, but if we could limit just the testimony regarding this while she's off the stand, that'd be preferable.
Now, did Shooting Star violate any of these best practices for firearm safety prior to May 28th?
Yes, there were actually 2 instances that specifically their employee Drew Cantrell violated of these practices before the meeting.
What was the first?
Well, the first incident occurred in May of 2021. When Drew Cantrell pointed a firearm at another person in the gun shop. This violated the first practice of firearm safety. Never pointing a gun at another person unless you intend to shoot that person. This is a basic rule of firearms that anyone, especially a professional, should know. And violating it shows a recklessness in handling firearms.
Did Shooting Star fire Drew Cantrell after this incident?
No, in fact, after giving only a verbal warning, Drew Cantrell was promoted to the position of gun safety instructor.
No. What about the second instance that Drew Cantrell violated the best practice for firearm safety?
Well, in November of 2021, Drew Cantrell violated, the 4th aspect of firearm safety. When she brought a loaded gun back from the gun range into the gun shop. Again, these practices are basics in handling firearms that anyone, even a novice, should follow. And not following even unloading guns when they're not in use shows a carelessness in handling firearms.
And was Skylar Coleman aware of this incident?
Yes, but same as last time, all that was done after the incident was a verbal warning.
So now I want to move on to May 28th. Do you have any issues with the Shooting Star actions surrounding this incident?
Yes, first I found that Shooting Star was unprepared to teach the safety course, and that Drew Cantrell was appointed as the instructor, despite Shooting Star's personal awareness of his repeated failures to follow basic firearm safety.
Why did you feel that Shooting Star was unprepared for the course?
Well, in my research, I found that Justice Scarborough had to repress any training herself. I found no evidence that Shooting Star had even prepared any materials in advance for the course, whereas most competent safety ranges or gun ranges at all have long-standing safety programs that include written materials and one-on-one instruction.
Now I want to move on to the accident itself on May 28th. Did Drew Cantrell violate any more best practices for firearm safety on that day?
Yes, on May 28th, Drew Cantrell violated 2 additional firearm safety standards.
What was the first safety standard?
Well, the first standard was the fifth aspect of firearm safety, always being sure of your target. And this is arguably the most important aspect. This extends beyond just being aware of this area surrounding your target, but the area surrounding the shooter as well. During the course, Drew Cantrell was teaching both Justice Scarborough and Nick Allred, but had both students standing only feet away from them. The rule aims to protect anyone surrounding the shooter in the case of an accidental misfire or shrapnel flying or anything else.
And what was the second best practice for firearm safety that Drew Cantrell violated on that day?
The second aspect that was violated on May 28th was the third, never pulling the trigger except with fire. After the first shot went off, Drew Cantrell lost control of the firearm that she was holding, and instead of maintaining a firm and steady grip like you should when handling the firearm, Drew Cantrell lost control and compressed her finger on the trigger instead of loosening her grip to prevent a second shot going off.
And did Shooting Star do anything in response to this incident?
No.
So now I want to move on to your additional analysis, Imperial's Responsible Firearm Sales Practice Act. What is this?
Well, the RFSPA, in short, is an act that prohibits the reckless sale or entrustment to someone who is, or the seller should know, is unfit to handle firearms.
And did you analyze Justice Scarborough's fitness to own a firearm?
Yes, I analyzed her fitness to own and utilize firearm safety.
And what did you determine in your analysis?
I found that Justice Scarborough lacked the necessary experience, training, and knowledge to handle, use, or own a firearm. Again, Justice Scarborough had to request any sort of safety training herself. And Shooting Star almost let her buy a gun and walk out of the shop with nothing to talk.
And did you analyze shooting stars and entrustment of a gun in Cantrell?
I did.
And did anything concern you about this entrustment?
Yes, Shooting Star again was personally aware of Drew Cantrell's repeated failures to follow basic firearm safety standards, but still allowed them to teach the course with no supervision.
Now, Dr. Judd, what do these sticky notes on this demonstrative represent?
Every aspect of the sticky note attached to it is an aspect that Drew Cantrell violated in her time working at Shooting Star Gun Club.
So after violating all of these best practices for firearm safety, is Drew Cantrell still employed at Shooting Star?
Yes, to this day, Drew Cantrell is still employed at Shooting Star.
Thank you, Dr. Judd. Thank you, Your Honor. No further questions at this time.
Before I begin with my cross-examination, could I ask that the demonstrative?
So why don't you, flip it over or take it down, whatever you prefer.
Yes, sir. Would you like me to move the eagle out of the way too, or? Would you like me to move?
Good afternoon, Dr. Judge. Thank you for being here today. You have been personally affected by gun violence, is that correct?
Yes, that's true.
And in response to this, you began advocating for gun control, is that right?
Yes, my niece was killed during a mass shooting at a Labor Day party, and it's changed the course of my career to just away from just enforcing the current laws we have around gun restrictions and advocating for more of them.
Before I begin talking about your analysis today of today's case, I would like to clarify, you didn't personally interview any of today's witnesses, is that correct?
I did not. I was only hired to review written.
And the materials you were given were all given to you by the plaintiff's attorney, correct?
That's correct.
Let's talk about Cantrell's incidents in May and November 2021. You believe that these two incidents make her unfit to handle firearms, is that correct?
Correct. These are the violations that she committed were of basic safety practices that anyone handling firearms must follow.
However, in these two incidents, nobody was harmed, is that correct?
No, nobody was directly harmed.
And neither incident was repeated, correct?
Not the specific incidents, but the repetition of safety violations were, yes.
A bullet was never fired from a gun during either of the incidents, correct?
That's correct.
Are you aware that Cantrell holds a firearm safety certificate?
I am.
Isn't that the safety certificate you hold, Dr.
That's true, but I do want to make something clear. Just holding a certificate in firearm safety doesn't make you inherently qualified to hold firearms for the rest of your life. It's similar to a driver's license.
Are you aware that there's an expiration date?
Objection, Your Honor. The opposing counsel, please let the witness finish answering the question. This is a expert witness and they're allowed to and they should be allowed to give their opinion thoroughly.
May I respond? Sure. The witness has answered the question on hand, and I just copy.
If you just at least let her finish her sentence, but you are permitted to control the witness at this stage.
Thank you. Are you aware that there is an expiration date on these?
That's correct.
And are you aware that your contract expiration date is not until 2025?
Yes, but again, it's similar to a driver's license. Just because your license is expired or that you have a license in the first place doesn't mean that you'll never get into an accident.
Are you aware that Cantrell has all the certificates required by law to teach the training course?
Yes, but again, it's similar to having a driver's license.
I'd like to talk about Cantrell's history with firearms. You're aware that Cantrell was a firearms safety certificate, right?
Yes.
You're aware that Cantrell was a firearms instructor.
1 second. Grounds for objection.
Objection, asked and answered. Dr. Doe has already said that she has knowledge that Drew Cantrell holds a firearm safety certificate.
And response.
I just simply wanted to hire.
I think for clarification, I'll let Pam go over.
You're aware that Cantrell was a firearms instructor certificate, correct? That's correct. You're aware that Cantrell has been teaching training courses for 9 months prior to Harvard, correct?
That's correct.
And you believe that even the most experienced gun owners can and do experience accidents. Is that correct? So would you agree that experience and accidents don't always correlate?
I'm sorry, how do you mean?
Experience of gun owners and the amount of accidents, or if they do experience accidents, they don't always correlate.
I suppose not necessarily.
Thank you. No further questions.
Reader,
Yes, briefly, Your Honor.
or
Dr. Judd, would your past experience with firearms affect your testimony in today's case in any way?
No.
Thank you. Thank you, Your Honor. No further questions.
any recross on that issue?
No, Your Honor.
Witness may be excused. Does plaintiff have any other witnesses to call?
No, Your Honor, at this time, the plaintiff rests.
Alrighty, we are gonna take a 5-minute break. Would you mind letting us know or putting a 5-minute clock on for us? Perfect, thank you.
Your Honor, just a request from the plaintiff that after we reconvene before we restart, we have a time check.
Oh, of course, yes, yeah. I mean, if you want a time check now, we can do that, just so you guys can plan ahead.
Whatever works best. for you.
Yeah, what are we at?
The plaintiff has 41 minutes and 49 seconds left, and, the defense has 39 minutes and 39 minutes and 21 seconds.
Do you concur? Perfect, alrighty, 5 minutes.
Your Honor, could you check on the status of my street?
Yeah, go right ahead, please. I am not in control of that, sorry.
Yeah, but you can't see you. Yep, no, you can. I know, I'm on the right screen.
Did you get deal with that? Okay, what? You don't spend off for the Oh, oh, wait, one of those on it or? What? Fine.
Yeah, we know.
No, you know, I would. No, it's. What are you gonna tell me? You have a lot of time. But yeah, we were taking, maybe 5 minutes. Yeah, we so we're like 2 minutes behind, like, the whole, yeah. Wait, what did you say? Said it.
Very.
Did we get everything?
Yeah, like, I think, oh, God.
We'll start in just a second. We're gonna make sure our jurors have enough time to submit their comments and everything. You guys can keep talking. Like, all right, are we good, jurors? All right. Defense, would you like to call your first witness?
I would now like to call Drew Contral to the stand. May I proceed?
You may.
Please introduce yourself to the courtroom.
Good afternoon, my name is Julie Kemp.
What is your relation to shooting star club?
Well, I work there. I'm a fire safety instructor at Shooting Center.
How long have you worked there for?
I started working there at June 10th, but it's been like approximately 3 years.
Did you have a relationship with guns prior to working at shooting star?
Of course, for my whole life. I've been interested in guns since I was a child, where my dad took me hunting. I was into shooting practice when I was in high school. I visited Shooting Star several times prior to my employment.
Could you please take me through the interview process for the job as a salesman?
So the interview, it was quite thorough, over an hour. It was basically about my life, my experience about guns, related to guns, and it was
When did you find out that you had gotten the job?
2 weeks after the interview.
What did your roles include when you first got the job?
Basically, it's just a cashier, managing the store's inventory, and so on.
What was your relationship with Miss Skylar Coleman?
We were great. I thought so until we had a small incident about me pointing at me suspected to be pointing a gun at another person.
I would like to talk a bit with you. If I could just lay some foundation first and ask the witness to open Exhibit 20. Do you recognize what this is?
Yes, I do. It is the memorandums that Tyler Coleman wrote about me about 2 incidents that went wrong.
And I wish to enter this exhibit into evidence.
No, Your Honor. Go ahead.
I want to take the instances addressed in this memorandum one by one. Could you please describe what happened in that first instance addressed in the memorandum?
So in May 2021, I was expected to be pointing a gun at the principal, but that did not happen. Like, why would I? Like, get fired?
So just to clarify, did you ever point a gun in the direction of another individual?
No, never. I was just expecting a gun, guess, pointing it towards the door.
Can you describe what happened in the second instance addressed in that memorandum?
So I admit what I have to admit. In November 2021, I brought a loaded gun back to the store's counter. This was my mistake, and I regret this totally.
Can I ask, was this mistake ever repeated?
No, not ever. After Ms. Pullman strongly recommended me. I was more aware about these instructions and the rules of student reference club and never really did.
Were you ever promoted in the job?
Yes, once.
What were you promoted to?
So I was originally a sales clerk and then I got promoted into environment safety and health.
What qualifications did you need for this role?
I needed a fire safety certificate and a fire instructor certificate to show that I am qualified and ready to instruct others.
And did you have both of these qualifications?
Yes, I do.
Were you working on the 28th of May, 2022?
Yes, I was.
Did you teach a training course on that day?
Yes, I gave a training course to Justice Carbo and Nick Almond.
When did you first meet Justice Carbo?
In the morning, after having a few words, I could know right away that he was experienced and he needed to take my course.
And did you teach the training course accordingly?
Yes, I did.
How did you follow the training course prior to May 28th?
Numerous. I worked as a shooting star employee, a fire instructor since August 2021. I had numerous courses. I took some using the blockchain.
How many people were taking the safety course on the 28th of May?
2, this is Carbo and Nick Almond.
Where did you teach the training course from?
The shooting range to specify Sol 11.
Could you please describe in detail what happened during the training?
So I first gave them safety equipment, basically earplugs and goggles. Then I positioned them where they would be safe and also take my course, seeing well and also take my course safely. Then I explained them about the basic safety rules and using it.
What happened next?
So in the course when I was showing how to discharge a gun and hold, aim, shoot one, after the first shots, just a car went in.
Continue.
So he hit me, I had to drop the gun. The gun was fired. It went to Justice Carbo's leg, making me confused and gone.
How many times did you pull the trigger of the gun while teaching the training course on the 28th of May?
Only once, as a citizen.
And where did that bullet go?
It went down to target.
Did Carbo hit off your arm before the second shot was fired?
Yes, he did, since it came too close.
Finally, do you have any closing comments in relation to the event that took place? on the 28th of May?
Objection, Your Honor, this isn't actually a question. This witness could essentially say anything she wanted. If counsel would like to ask a more specific question on whether they want this witness to answer, they can do so. But any closing statements or comments is not a valid question.
Response? I simply want the witness to be able to describe his or her raw account of what happened on that day, and I want to ensure that the courtroom is hearing everything that the witness will say.
Then, Your Honor, they can ask questions specifically to the things that they want this witness to be able to say, but asking any closing comments or remarks is a vague question and will be misleading to the jury because this witness could essentially say anything.
Why don't you ask what you exactly what you want to elicit, her account of what happened, you can ask that, so I'm gonna sustain, but certainly you feel free to ask an open-ended question as to what you saw, what you heard.
Was it your, do you have the witness of fault to what happened to Carbo?
I do think this is a tragedy. I feel sorry for this happening to Carbo. This is not what I expected or I could have expected since it was Carbo who came close to me and helped me.
Thank you. No further questions.
Cross?
Yes. Good afternoon, Ms. Cantrell.
Good afternoon.
Now, you've been convicted of reckless driving, correct?
Yes, I was.
And the misdemeanor DUI?
Yes.
Objection, Your Honor. I wish to raise an objection as this is more prejudicial than probative.
Your Honor, may I respond? This testimony is part of an essential element of the claim. According to the case law, page 3 Seaton versus Patron. The character evidence of this witness is an essential part of the claim of negligent hiring, supervision, and retention as it's about the hired employee, which means that it can come in during today's trial.
And what specific language in the Seaton case permits you to bring in this character evidence?
Your Honor, it says that, testimony of testimony of the employee hired is an essential element in negligent hiring, supervision, and retention cases.
Any response?
We're not disputing the testimony, we simply think that the past actions of Ms. Cantrell should have no effect on her day-to-day dealings in Shooting Star or what happened in Shooting Star, as it's prejudicial and the jury may view her differently within knowing the information on her past.
Your Honor, may I be heard?
One last time.
For testimony to be more prejudicial than probative, the prejudicial effect has to substantially outweigh the probative effect. The probative effect of these prior convictions goes to the recklessness of this witness, and therefore they could have been reckless during their tenure at Shooting Star Gun Club, which means it does have a substantial probative value, which means that the probative value substantially outweighs the prejudicial value, which means it can come in today's jury.
I'm going to overrule based on, it is prejudicial, but in terms of the prejudicial effect, does not substantially outweigh the probative value specifically due to the claim that plaintiffs have brought in the negligent hiring.
Thank you.
Now, you were convicted of a misdemeanor DUI, correct?
Yes.
I want to talk about whether Ms. Coleman knew that. Now, you had an interview with them when you wanted to start a job at Shooting Star,
Yes, I did.
but these convictions never came up during the interview.
Yes, like Skylar wouldn't have expected me after that.
Right, and you never asked if you did.
Well, she took my driver's license, but she never asked me.
Right. Now, I want to talk about what else happened during that interview. When you were talking to Ms. Coleman, she told you that they were desperate to bring in more business.
Because it was right after COVID-19, and
But that's a yes to my question. She said she was desperate to bring in more business.
of course, every business woman will manage.
Now, let's talk about what else happened during that interview, or what didn't happen. You weren't asked why you left your previous job, correct?
Yes,
Well, let's talk about that. You previously worked at Imperial Engine,
yes, I did.
and you were fired, right?
Yes, I was.
And you were fired for being drunk on the job, correct?
It was their reasons that I wasn't drunk.
Ms. Cantrell, I'm not asking for your version of events. I'm asking what you were fired for. And you were fired for being drunk on the job, correct?
That was their reason.
Now, let's talk about your time at Shooting Star. You worked there as a firearm safety instructor,
Yes,
and you talked about 2 incidents you've had over your tenure, correct?
yes,
The first one being pointing a gun at another employee,
yes, but I wasn't.
but that's what Ms. Coleman accused you of.
That's what she accused me.
And you also brought a loaded gun outside of the shop, correct?
Yes, but and
Now, Your Honor, may I approach the witness with what has been entered into evidence as Exhibit 20?
You may.
Now, you understand this as your memorandum that you received from Ms. Coleman, correct?
yes, it is.
And she writes, correct me if I'm wrong, that during your first incident, you violated company policy, correct?
Yes,
And also best practices,
yes,
but you weren't fired, Ms. Cantrell, correct?
yes, because I understood my mistake,
But you weren't fired.
yes, I wasn't.
You weren't suspended,
Yes, because I didn't point a gun at anyone.
but that's what she accused you of and then didn't suspend you, correct?
Because there were some people who think so.
Right. And it didn't require any retraining
Yes, because those never happened.
or any additional supervision.
As I said, I did not point a gun, so nothing else was needed.
But Ms. Coleman believes that you pointed a gun at another employee,
I
correct?
did not.
Objection, asked and answered. I think the witness clarified that Ms. Coleman accused you of it.
Your Honor, may I be heard? This witness, after every answer, is saying, no, I didn't need retraining or supervision because this never happened. But what I'm trying to get the jury to understand is that Ms. Coleman believes that it happened and still did not give this witness any additional supervision, training, or suspension, nor were they fired. And so I need this witness to validate that Ms. Coleman believed that and sent out this memorandum due to their belief that they thought that they pointed a gun at another person and still did not go through with any other requirements.
Any response?
My witness has validated that Ms. Coleman, did accuse her of pointing a gun at another figure, so I just don't see, the necessity to repeat the question.
This is just a clarifying question as was throughout the process today, Your Honor.
I think it is clear on the record that, Ms. Coleman did believe that that Drew Cantrell did point a gun, so I think that is clear, but I don't think that the witness has completely answered more direct questions. I'll allow a little wiggle room to that, but I think it is clear for the record that it was Ms. Coleman's, position that the gun was pointed, so. In terms of getting your answer, you can proceed, but just in terms of, I think it's clear for the jury and for the record that, Ms. Coleman did believe and had pointed that out to you.
Yes, Your Honor. So you didn't require, Ms. Coleman didn't require any retraining
Yes, I said it wasn't needed.
and no re-supervision,
I said it wasn't needed.
but she didn't require any supervision after the incident.
It wasn't needed.
Now let's talk about the second time in that same year. You violated company policy again
Yes,
and violated best practices again.
yes,
But again, you weren't fired,
yes,
nor were you suspended,
yes, I was.
nor was any retraining asked of you.
Because what retaining do you have to gain?
No retraining was asked of you, correct, Ms. Cantrell?
Yes,
And no more supervision was asked of you, correct, Ms. Cantrell?
Yes.
Now, I want to talk about the day of May 20th. You were asked to teach a safety training course that day,
yes,
and Ms. Coleman specifically asked you to do so.
yes,
Do you remember, and Ms. Coleman specifically texted you about doing so, correct?
yes,
Would you recognize those texts if you saw them today in court?
yeah, but
Your Honor, permission to approach the witness with what has been previously marked as Exhibit 18.
Yeah.
Ms. Cantrell, do you recognize these as the texts you received on May 28th?
yes,
And are they a fair and accurate copy?
yes,
Now, Your Honor, plaintiff would like to admit Exhibit 18 into evidence.
Any objection?
No objection, sir.
Now, correct me if thank you, Your Honor. Now, correct me if I'm wrong. The day of May 28th, this is the same day you taught the training course, correct? Ms. Coleman specifically says, I don't want to hear about any more of your mistakes again, correct?
Yes.
No further questions at this time, Your Honor.
Any redirect?
Yes, sir. Opposing counsel brought up your misdemeanors. Are any of your misdemeanors that are sentenced related to firearms?
Objection, Your Honor, leading.
Any response?
I just want to simply ask a question about whether the firearms are on.
Your Honor, this is a direct examination and opposing counsel cannot ask what is their redirect examination of leading questions.
Can you repeat your question?
Are any of your sentenced misdemeanors related to firearms?
I don't believe that question elicits an answer, so I will permit it, but please keep the questions open-ended.
Yes. Would you like me to repeat the question?
no, it's fine. It's not related to that at all.
Were you drunk on your job as your job was fire as a mechanic?
No, it was their excuse and I was never drunk that.
No further questions.
Any recross?
No recross, Your Honor. May I get my exhibit of the witness stand? Your
Sure,
Honor?
of course.
Thank you.
And you need the excuse. Vince, call your next witness.
You called the second witness, Ms. Garda Coleman.
Thank you, please.
You may.
That's me in the comment. Now, what do you do for a living? I'm the owner of Chicken Star Club. And what is the Chicken Star Club? So first and foremost, Chicken Star is the owner of chocolate. It's not more than that. It's family. And what would you consider important as in your role in life? I'd say one of the key things about my role in life is here at Chicken Star is fostering a community. I didn't want to just be a gun shopper who provide on and then back. I want their patients to feel family. Now, in your deposition, you mentioned that you recently opened a bar and cafe. Could you please make the court aware on your previous?
Objection, Your Honor. And on direct examination, a witness cannot have to be asked questions that reference their own deposition. There is a procedural rule, I believe, on this. If you'll give my counsel a moment to find it.
Sure. Do you have a response?
I can continue with that. I would move on.
Would you like that testimony to be stricken?
Yes, Your Honor.
So stricken.
Could you please make the court aware on your decision with regards to alcohol in the context? Yes, so I'll just give an example to my famous here. If a person involved in the bar and ordered any alcohol, we would ask them to do that, which was later. If it's a death, we would ask them not to shoot, or if they want to shoot, we would ask them not to drink. And how are your customers made aware of this? We have signposts posted throughout Chicken Star to make the customers aware of cases where alcohol cannot be brought into or between just reminding them, and of course, the fire staff will be must. And where are these signs displayed? As I said, throughout Chicken Star. Thank you. Now, are you aware of individuals as an industry center? Yes, I am. What was the hiring process like? So capture the opportunities to make an application for job. And from there, I organized each to be that personally, so I could understand it better. And did she have any prior knowledge? Yeah, it was clear to me in the interview that she had a great knowledge of fire and gun. She had been using those recreations full life for hunting and was part of her archery in high school as well. And what role did you exactly hire myself for? Originally, I hired them as a sales clerk managing the inventory to sell fire. What were the requirements established? All we needed was to teach her how to use the system, have a place, and she was there, and those techniques have as well. And did she need them? Yes, she did. Now, what were the requirements for contract and safety instructor? I'm sure the contract has earned a firearm safety certificate and served other firearm safety instructors in the area prior to promoting her. And could you clarify for the sake of the court what this certificate is? The certificate ensures that this person is qualified to teach the gun safety course. Now, did you meet the requirements required for this job? Yes, she did. Now, let's talk about George, an employee. How did you view her as an employee? She was a very hardworking, diligent employee. She followed instructions well, and she was always ready to help anyone who was there and help. And how do your customers feel about you? I mean, customers loved her. She was great on the team, and I always only ever heard of the glowing reviews about how she helped others, and was always open to any questions or queries that customers have with her. Thank you. Now let's talk about those two incidents involved in Drew. Would you please tell us what happened with the first one? Yes, so the first incident happened in May 2021, where Drew allegedly pointed a gun at another person. Sorry, Ms. Coleman, you said allegedly. You know, Drew Cantrell actually pointed a gun at another person? I was in the shop at the time. I was in the storage area, so I didn't witness the event myself. Now, was there ever a repeat of this particular incident? No, Drew never repeated this again. Thank you. Now, what was the second incident? The second incident occurred in November 2021, where Drew brought a loaded gun into the main area of the store. And did those actions then? Those actions never happened again. Now, how was she reprimanded for these? On both occasions, I gave Drew what I believe was probably the most ruthless lecture of my entire life. I never thought I was able to be that harsh to someone, and I just see the look on her face. She understood what I was saying to her, and that if she had repeated those actions ever again, there would be serious consequences. Now, do you know an individual by the name of Justice Carwell? Yes, I do. Did you ever meet with Justice Carwell in person? Yes, I first met with Justice Carwell in person on May 14th. Did you have any contact with Justice Carwell prior to meeting her in person? Yes, prior to meeting her in person, we had spoken via email. Could you tell us about this email? Yes, in these emails you can hear at times I have kind of hostile and sensitive tone towards Ms. Carwell, and I just want to say that I have to admit I'm a bit old fashioned. I'm not the biggest fan of emails, and I just don't really get a lot of technology that well.
And also firearms are a very dangerous weapon, and I want to meet this Cargo in person, so he's fully answering the questions in a better way.
Thank you. Did you figure out what firearm was most appropriate for this cargo?
Yes, this Cargo is very communication, he's absolutely getting, I want to handle the self-defense. I thought an opportunity would be perfect for her.
And did Miss Cargo like fire?
Yes, Miss Cargo had purchased the fire.
And did you do anything prepared for the fact she was a female?
Yes, and Miss Cargo was obviously a absolutely novice. I offered her our complimentary safety training course, which we give to all of our customers, new or old, experienced or non-experienced, to ensure that they understand how to safely use the iron that they use.
Thank you. And just to lay foundation, if you could fit to 13. Have the court what this is?
Exhibit 13 is an advertisement, the shooting star commercial advertisement script.
And now ask why could it fit into the 13 into evidence?
Any objection?
Hearsay?
Your response?
I don't think it's a hearsay, it was a widely published ad and the whole community seen it.
No. It is not a court statement that I believe is being offered for the truth of the matter, and so therefore it is hearsay.
And we previously heard that other witnesses in this trial have heard of this, so I believe it's legal as you mentioned then that my client should have a chance to comment on this.
Are you planning to have the witness read exactly what this exhibit says?
Just the effects of this jingle.
So you don't plan to elicit any statement in there for the truth of the matter?
Just comment on what was said in it, but nothing specifically quoted.
Your Honor, if they're taking comments out of this ad and speaking them to the court, it would be offered as out of court statement offered the truth of the matter, as this is a script of the ad.
Do you have any response?
I can move on now.
Well, let's hear the questions and then you can raise your objection. My fear is just, a direct reading of this transcript into the record that be hearsay, but if you're using it for, not for its truth matter, but rather any information she may have on it, that would be a different situation. So let's hear the questions first, and then if you feel that it is being read into the record or that it is hearsay, it's gone beyond just it's being offered for its truth, then you can re-raise your objection.
And could you tell us the effects of this ad?
Yes, so we have this ad to kind of advertise to start as something, and we need to remind our people and future customers that we offer a safety training course. So not only will our customers be first thing on, but they would also be taught how to use safety.
Thank you. Now back to the training course. Can I ask you who suggested this course?
I suggested this course to Cargo as she was complete.
And did the Cargo partake in this course?
Yes, she did.
Thank you. Now, would you recommend or would you recognize the good sense the liability waiver? Yes, I would. Thank you. Now, addressing the city liability has been previously entered in evidence. Is this the liability form that you gave to Dr. Cargo?
Yes, it is.
And why did you give it to her?
I gave this liability waiver and whether it was to any customer who enters the premises that she would set. It is to make sure that all of our customers are aware of the risks and hazards associated with the unit.
And finally, why did Justice Cargo sign this form?
Yes, she did.
Thank you, Your Honor. Nothing further.
Yes, yeah. Good morning. Now, before Ms. Carbo came in to learn about guns, to buy a gun, you two had been emailing for quite some time, correct?
Yes, I sent her back 2 days notice prior to me meeting her.
You would recognize the first email Ms. Carbo sent you, Carter shows to be here in court today, correct? Your Honor, at the time, may I approach when this was pre-marked and exhibit 15A?
You may.
Do you recognize this as the email Ms. Carbo sent you?
Yes, I do.
Is this a fair and accurate copy of the email Ms. Carbo sent you?
Yes, I do.
At this time, the plaintiff offers exhibit 15A is evidence.
Any objection?
Hearsay?
May I respond?
Did you have anything further?
This is an out of court statement.
Your response?
Yes, this goes to the state of mind of Ms. Carbo when buying a gun, and as reckless entrustment is one of the claims in this case. Ms. Carbo's state of mind, in particular, what's the most depicting her novicehood, is an essential element of this case, therefore it's not hearsay.
And a response to the exception under a state of mind.
State of mind, I believe it is hearsay. If it's being directly quoted, that is hearsay. But if she's on the effect of this, I have no problem with that.
Your response to how are you planning to use it, I guess? What do you proffer?
Yes, Your Honor, I'm planning to use what Ms. Carbo describing her experience with guns with this email. Therefore, her experience with guns, her background with guns is very essential to this case, and it goes to her state of mind in buying a gun.
I'm going to overrule as a statement part, as long as you say to Ms. Carbo's statements regarding her specific state of mind, that will be admitted under the exception. But anything other than that, that will also have to be admitted under exception and therefore sustained as a.
Yes, Your Honor. Now, in this email, Ms. Carbo, she explained that she's never used a gun before, correct?
Yes, we did.
Explained that she's never shot a gun before, correct?
Yes, that's correct.
In fact, Ms. Carbo explains that she's never even held a gun before. Isn't that right?
Objection, Your Honor, I believe these are quotes from the email.
You are not quotes from the email, Your Honor. I am simply taking what the email says and then creating questions from it.
I believe she's directly quoting what is said and adding a correct at the end. I believe this is quoting.
Your Honor, I can.
What exhibit is this again?
15A, I can add an additional exception to this hearsay if needed.
Sure, what else?
It could go to the effect on the listener, Skylar Coleman, as he was selling her the gun. And as this goes to Skylar Coleman's reckless entrustment of a firearm to Ms. Carbo, her knowledge around guns would make that this exhibit is not hearsay that goes to Ms. Coleman's state of mind of selling her a gun.
It's an out of court statement, Your Honor.
I'm operating an exception to the fact that it is hearsay.
I'm gonna overrule as to Ms. Carbo's statements are under the exception of state of mind. And if you're only offering the other statements as an effect on the listener, not for its truth matter, we will instruct the jury to only take it for the effect on the listener, and it will not be admitted as for the truth of the matter asserted. So under a special instruction, we will instruct the jury as to only take those out, the other statements other than Carbo as only effect on the listener, and you know, after the trial, the judge will instruct the jury on that.
Yes. Yeah. So after these emails, you asked Ms. Carbo to come down to the shop, correct?
Yes, I did. I wanted to speak with her in person and fully understand better what she wanted to do.
And after that first meeting, Ms. Carbo, she then came in on May 28th, and that's when she bought her gun, correct? And May 28th, you assigned Drew Cantrell to teach the safety course she asked for, correct?
Yes, I had. I prior mentioned through how a safety course to knowledge to get a
Now I want to talk about Drew Cantrell a little more. So when you hired Drew Cantrell, you didn't know they had ever held a job where they could develop professional gun experience, correct?
No, but they have experience using guns as a use of recreation the whole life or something.
But that's not professional, it's only recreational, correct?
Yes, correct.
So after you hired them, you promoted Drew Cantrell about a year later, correct?
Yes.
You promoted Drew Cantrell because of their enthusiasm, right?
Enthusiasm was a factor, but it was not the sole factor in hiring.
Yes, in fact, you also promoted Drew Cantrell because it's good for Shooting Star Gun Club's checkbooks, right?
It's always great to promote someone who's been with the company before.
That was not my question, Ms. Cantrell. I'm asking, you promoted Drew Cantrell because it's good for Shooting Star Gun Club's checkbooks, correct?
Objection, Your Honor, more prejudicial than probative.
Your Honor, yes. Your Honor, this is not more prejudicial than probative, as the probative value outweighs the prejudicial value on the jury. Excuse me, Your Honor.
Take your time.
Yes,
Fine. No worries.
Ms. Coleman's reasons behind hiring Drew Cantrell are essential to this case. If she hired Drew Cantrell due to the effect on the company's budget, then that goes directly to negligent hiring, which is an essential element in this case, and therefore the probative value greatly outweighs the possible prejudicial value on a jury.
May I respond?
Sure.
I believe there were definitely more factors in the hiring of Drew Cantrell, and opposing counsel to zone in specifically on one factor, making prejudicial effect on the jury. I believe it is more prejudicial than probative.
Your Honor, opposing counsel can address those concerns on redirect, but on cross, I'm allowed to ask this line of question.
I'm going to overrule. You are certainly allowed to ask your witness if there's any other factors on redirect. And of course, you may recross on that if you wish. I'm going to overrule for now. You may proceed.
Yes, Your Honor. Now, you also promoted Drew Cantrell, despite the fact that they never taught a gun safety course before, correct?
No, but everyone's done that somewhere. I mean, our Pat Lorenzen, who was our safety instructor before Drew, began in our student set.
Yes, but you were concerned about the fact that Drew Cantrell had never taught a gun safety course before, correct?
Like I said, it was just that job. There's obviously a slight bit of concern. That's all.
Your Honor, permission to strike everything before there was slight bit of concern as non-responsive?
Agreed.
Yes. So now I want to talk more about Drew Cantrell as an employee. Now, throughout Drew Cantrell's employment at your company, there were two incidences where she mishandled guns, correct?
Yes.
There was one in May 2021 where she pointed a firearm at another employee, correct?
Yes.
And there was another in November of 2021 where she brought a loaded firearm into the gun shop, correct?
Yes. That's not the best practice, but treat every gun as a loaded anyway. No one would avoid danger.
Now, after both of these incidences, you didn't fire Drew Cantrell, did you?
No, I didn't see need, I mean, to be for mistakes, and I had to reprimand you both. And I'm new to this book, well, everything.
Now, to instruct the witness to answer yes or no to the question, you didn't fire Drew Cantrell.
Objection, Your Honor. I believe my client should be allowed to answer how she wishes. She did answer the question and she gave reasoning behind it, so I don't believe a yes or no is sufficient for this kind of question.
This is cross. You may control the witness as you wish, unless the witness goes on and is not truly answering your question. I believe that the witness did say, give a yes or no response.
Yes, Your Honor.
You may always move to strike anything, but
May I move to strike everything besides the yes in the question, Your Honor?
granted.
So after Drew Cantrell mishandled guns 2 times, you didn't suspend them either, did you?
No, I didn't.
You didn't train them, give them any further training, did you?
No, the verbal warnings were not on purpose.
So after Drew Cantrell had mishandled 2 firearms, you assigned them to teach Ms. Carver her safety training lesson, correct?
Ms. Cantrell had Joseph leaders from the Hall of Function Empire, so I didn't see why I shouldn't have.
But that was not my question, Ms. Coleman. I asked that after these 2 incidents where she mishandled guns, you assigned Drew Cantrell to teach Ms. Carver's safety lesson, correct? So on May 28th, Ms. Carver walked into that gun range to take her safety lesson, correct?
Yes, I made a mistake.
But on May 28th, instead of walking out of that gun range with a full safety course, Ms. Carver left with a bullet in her leg, correct?
Yes, that was a tragic accident. I had never heard it before.
Thank you. Your Honor, no further questions.
Any redirects?
Yes, Your Honor. Now, Ms. Coleman, what kind of person do you believe Drew Cantrell is?
This Cantrell is hardworking.
Outside the scope of my cross, Your Honor.
She has been commenting on Drew Cantrell. I believe it doesn't fair that I'm asking her to comment.
Your Honor, may I respond?
Please.
I'm talking about Drew Cantrell in an employment setting. The type of person Drew Cantrell is was never in my line of questioning cross, only their employment history and their background history before hiring.
May I rephrase, Your Honor?
Yes, well, if you can make an offer of what your rephrasing would be.
And what kind of person do you believe, or what kind of employee do you believe Drew Cantrell was?
I'm going to overrule objections so long as you ask about the employment context.
And what kind of employee do you believe Drew Cantrell was?
Drew Cantrell is a hardworking employee. They're very open to helping other customers.
Objection, Your Honor, improper character evidence, too hardworking.
Any response?
I believe this is their opinion. I don't know.
I'm going to overrule. She was the one who hired Drew Cantrell, and this is a negligent hiring case. So I'm going to add a little leeway in terms of phrasing of what her perception was of Drew Cantrell when hiring.
I ask you to repeat your answer this moment, but it says you're a very hardworking employee and very open to helping others with any of your questions. Thank you, I'm done with the question.
Any response?
No, Your Honor.
Witness may be excused. Okay. Defense, would you like to call your next witness?
I'd like to call it on witness for seconds. Good afternoon, Ms. Salt. Please introduce.
My name is Dr. Snell, and I'm the firearm chief examiner at my here.
And you tell us about your certification.
Yes, I have two firearm safety certificates, one from the Imperial Department of Justice and the other from the U.S. Bureau of Federal Firearms.
You tell us about your company installed this on this.
Yes, we work with all things firearms from analysis to gun making.
And can you take us through your education?
Yes, I have a bachelor's in physics with a minor in economics, as well as 7 years of grade.
Thank you for yourself and everyone here in this time for this. And now, in your expert opinion, how do you reduce problems that results in gun violence?
Objection, Your Honor, and further expert opinion.
I don't think any testimony has been elicited quite yet. Are you objecting to the question specifically?
Yes, I'm objecting to the question, Your Honor. It has not been established that Ms. Jackie Fowler is an expert in any field after having this direct examination. So any expert opinion whatsoever would be improper until Jackie Fowler is established.
Well, in order to ask the question, can I stipulate Chuck Salt as Mr. Witness?
Has there been a stipulation agreement as to the expertise of this witness?
Your Honor, as per stipulation 13, Jackie is tendered as an expert in the field of firearms mechanics, though the ways in which Imperial may combat gun violence is not within the field of firearms mechanics.
Okay, why don't we start off with tendering the witness as an expert, and then you can ask your question and just clarify what the witness is an expert in, before asking that question.
Oh, I can stipulate his witness as expert in firearms and mechanics.
Any objection to the expert?
Yes, Your Honor, for clarification, the witness is not an expert in firearms and mechanics. The witness is an expert in the field of firearms mechanics, they narrow field, but other than that clarification, no objection.
Sure, so firearms mechanics, as a one title, she will be entered as, she'll be noted as an expert.
So, in your expert opinion, how do you reduce problems that resulting from the
Objection, Your Honor, in further expert opinion, this question falls outside the scope of the witness's expertise.
In your opinion, how do you reduce problems that result in conflict?
In terms of how do you can repeat the question, I'm sorry, I know your throat is like you're sick, sorry, I'm sorry, thank you for repeating it.
How do you reduce problems that result in a relationship?
And how is that question connected to her expertise as an expert in gun mechanics?
In general, with her expertise in this firearms,
Your Honor, this witness is not tendered as an expert in the field of firearms.
I can move on.
If you want to lay a little foundation as to what she does maybe day to day, if she has any methods or if she has any expertise in that specific in that field, you may lay the foundation to then ask the question. But unless there is no foundation that can be laid for her to answer that question, I will sustain.
So, in relation to this case, when were you retained by this?
November of 2020.
And were you asked by any specific answers to this case?
Yes, number one, whether or not the jury counsel complied with industry standards when included in the gun safety course, and also whether or not the instructions of the doctors to violating and not.
And have you done any further investigation to this case?
Yes, I read the definitions of cargo and woman as well as the aspect of UN knowledge and conduct. I also looked at the business management.
Thank you. Now, using your expertise in firearm mechanics, complete a base topic of firearms. For the length of the jury, can you please explain how firearms works?
Yes, the
cartridge of the firearm sits at the base in front of the pin. When the bullet is struck, the pin strikes the bottom of the cartridge, which ignites the gunpowder within it, which launches the bullet outwards.
And specifically, how does the Glock 22 work?
So the Glock 22 is a semi-automatic handgun, meaning that it reloads automatically, but only one bullet can actually exit the firearm per pull of the trigger. A very sensitive trigger, it's just kind of how the Glock 22 is manufactured.
And what's the gun user? Is this gun?
Yes, it's often given to beginners.
Objection, Your Honor, improper expert opinion.
Response? Sustained.
What the interest of the Glock 22 should answer reckless, such as violation of the law.
Objection, Your Honor, calls for improper expert opinion.
Response?
Again, on the one.
Sustained.
Once the crime shall qualify to be control.
Objection, Your Honor, calls for improper expert opinion.
As this witness has read through all of the affidavits and depositions, I'd like to excuse her and watching her.
Your Honor, if opposing counsel would like this witness to offer a lay witness opinion as to what she has read, they may do so, but this witness is not tendered as an expert in, those witnesses only tenders an expert in the field of firearms mechanics, and someone's fitness to own firearms is not within that field.
May I just ask the witness for opinion on what she read?
She may offer a lay opinion, but it can't go beyond, just, based on what she read. As if she was a lay witness in this aspect, she can testify to what she read and her basic opinion, but nothing beyond that.
Yeah.
You may re-raise it. Fine, necessary.
Was true crime shall qualify to be safe district?
Yes, Drew Cantwell has all of the legal requirements in order to become a safety instructor. So
Objection, Your Honor, speculation.
And response? I might not be this speculation, this is saving.
Your Honor, given that this witness is not offering this as an expert opinion, the opposing counsel was not laid the proper foundation that this witness would know what the legal requirements were. Only what Drew Cantrell said in their affidavit, the legal requirements were, and this witness has not established that they believe that everything in that affidavit is known to be 100% true.
If this witness has reviewed any material as to what the legal requirements are, such as statutes, and then also in congruence with reading Drew Cantrell's statement, you can lay that foundation for her to offer that opinion. But for now, I'm gonna sustain.
But what is institutional training course and institutional training course? Yeah.
Objection, Your Honor, improper expert opinion.
No.
This one.
Oh, this instance for probably overly sensitive training. That's correct. She can start trust going to certified gift instructor.
Objection, Your Honor, meeting.
I'm just reconfirming what the witness starts.
We've had a little bit of back and forth, so I think a little clarification is okay for this. I don't think your question elicited an answer for the witness, so I'm gonna allow it.
After thorough questioning, she can start solicitation on for years.
Objection, Your Honor, improper expert opinion.
We clarify this back on her as the
I think in terms of, this does fall within her expertise, so I'm gonna overrule the questions about whether it was a single gun and with her background in gun mechanics, I will prevent this testimony.
And she can start on for the training course.
Cross.
Good afternoon, Ms. Brown. You testified on direct examination that you believe the shot that hit Justice Carbo was caused by the Glock 22 was overly light trigger. Is that correct?
yes, Glock 22 is part of that training.
But Ms. Staub, you are aware that Glock 22s are known to have light triggers. Is it your testimony on the stand today that the light trigger of the Glock 22 was not in any way unusual for Glock 22?
Correct.
All right. Now, you examined the Glock 22 that Drew Cantrell today's case. Is that correct? But you didn't perform any tests on the gun, did you? Did you never even fire the gun?
I don't know.
So you have no empirical data supporting your conclusions in today's case?
Well, you can pull the trigger without firing the gun. There's no cartridge.
So is it your testimony that you did pull the trigger of the gun in today's case?
Yes, I found the gun.
I'm not asking whether or not you examined the gun to stop. I'm asking whether or not you pulled the trigger.
I didn't fire the gun, but I pulled the trigger.
Right, now, Mr. You wrote an expert report before testifying.
Yeah.
And in that expert report, you swore to include all relevant information to the case. All right. Now, permission to approach the witness with a copy of their expert report.
You may
There's no one for to look at the board.
take your time.
Objection, Your Honor, is my son speaking to provide with this defense?
So, would you agree with me there's nowhere in your expert report do you state that you pulled the trigger to Glock 22?
I state that I found the gun.
But bringing you back to my question, in your expert report, you never stated that you pulled the trigger to Glock
And
22.
the examination of the gun is all in there. My entire examination is going to be completed.
So, you, in your expert report, apart from saying that you examined the gun, you never said anything about the way in which you examined the gun?
I didn't miss out exactly what I did.
In fact, you didn't include any information in your report about what that examination looked like.
No, I did not.
Thank you, Your Honor. No further questions at this time.
Yeah, just go ahead, you can retrieve it.
Thank you.
Any redirect? You may put that. Defense, do you have any other witnesses to call in your case?
No, Your Honor.
Defense rep?
Yes, I do.
Alrighty, so we're gonna take a 5-minute break again. Why don't you let everyone know what the times are so they can prepare for the close?
Plaintiff has 19 minutes and 36 seconds remaining, and defense has 23 minutes and 9 seconds.
Do you concur? Alrighty, 5-minute break and we will then be closing argument. How are you guys doing? I've heard.
Yeah, just fighting at the politics.
You have to wear your good. Yeah. Yeah.
All right, is plaintiff ready to proceed for closing arguments?
Yes, you are.
And before you begin, are you reserving any time for rebuttal or yeah?
However time I have left on the clock is my vote.
Sure.
Justice Carbo getting shot was an accident waiting to happen. On May 28th, Justice Carbo was instructed to stand next to a person who had an established record of reckless behavior and breaking the basic rules of gun safety. And on May 28th, Justice Carbo was shot. It was an accident waiting to happen because Shooting Star Gun Club was negligent in their employment of Drew Cantrell and reckless in their sale and entrustment of a firearm. And so tonight, counsel for the plaintiff have brought two claims against Shooting Star Gun Club. One, that they were negligent in their hiring, retention, or supervision of Drew Cantrell, and that it was the direct and proximate cause of Ms. Carbo getting shot. And second, that Shooting Star Gun Club was reckless in their entrustment of a firearm to Justice Carbo, and reckless in their selling of a firearm to Justice Carbo and entrustment of a firearm to Drew Cantrell. So let's start with negligence, because we proved beyond preponderance of the evidence that Shooting Star Gun Club was negligent in their employment of Drew Cantrell with three simple facts. One, Shooting Star Gun Club should never have hired Drew Cantrell. Two, Shooting Star Gun Club disregarded Ms. Cantrell's numerous gun safety violations. And three, that disregard, that neglect by Shooting Star Gun Club was the direct and proximate cause of Justice Carbo getting shot. So let's start with the first fact, that Shooting Star Gun Club should never have hired Ms. Cantrell. Members of the jury, Ms. Cantrell's employment at Shooting Star Gun Club was a reckless disregard for the patron's safety. Skylar Coleman failed to adequately investigate any of Ms. Cantrell's backgrounds. Now, Ms. Cantrell testified in court today that they had never held a job where they could develop professional gun experience before. Ms. Cantrell testified that while they had been fired from a previous job for being drunk while at work, Skylar Coleman asked no questions when hired. Now, additionally, Drew Cantrell talked about their criminal record, a record that Skylar Coleman failed to even acknowledge in her hire. So about a year later, when promoting Drew Cantrell, Skylar Coleman again banned. Because they didn't promote Miss Cantrell because she was qualified. No. It was because of Miss Cantrell's enthusiasm. And because having a sales clerk become a gun safety instructor was easy on their checkbooks. Members of the jury, we've established that Shooting Star Gun Club should never have hired Miss Cantrell. And we can move on to our second fact. The Shooting Star Gun Club disregarded Miss Cantrell's numerous gun safety violations. Now, Ross Hernandez took a stance then, and he told you about Drew Cantrell's dangerous and alarming behavior while employed at Shooting Star. He told you about the fact that in an argument with another employee, Drew Cantrell pointed a gun at them. Now, Dr. Morgan Judd explained today that in doing that, Drew Cantrell had violated one of the most basic rules of gun safety that everyone should know. You never point a gun at someone unless you intend to shoot them. Ross Hernandez also explained that Skylar Coleman was in the room and watched as it happened. But Skylar Coleman's only response to that dangerous behavior by Drew Cantrell? A verbal warning. So that disregard by Skylar Coleman, unfortunately, it led to another incident where Drew Cantrell jeopardized the lives and safety of those around them and broke basic gun safety rules. Drew Cantrell brought a loaded firearm into the gun shop. Now, after Drew Cantrell broke their second gun safety rule, were they fired? Were they suspended? Were they given any training? No. And thus the plaintiff has established that Shooting Star disregarded Ms. Cantrell's numerous gun safety violations. And we can move on to our third fact. Shooting Star Gun Club's disregard, their negligence, caused Ms. Carbo to get a job. We know that Skylar Coleman had a job. They had a job to hire someone competent enough to teach gun safety. They had a job to keep their customers safe. Skylar Coleman, knowing that, still decided to hire Drew Cantrell, a person we know from today's trial was vastly underqualified to handle firearms around any customers. Now, Drew Cantrell had broken gun safety rules, had risked the safety of others, all under Skylar Coleman's supervision. Sadly, on May 28th, Ms. Carbo was the victim of Shooting Star Gun Club's negligence. The negligence in their duty of care to ensure that a woman like Ms. Carbo, Ms. Cantrell, would never be able to hold a firearm around a customer. And so, given the totality of the circumstances, given all the actions that Skylar Coleman refused to take, we know that the defendants' disregard, their negligence, was the cause of Ms. Carbo getting shot. But today, the plaintiff, we brought a second claim to this court: the reckless entrustment and selling of a firearm. And Dr. Morgan Judd explained today that neither Drew Cantrell nor Ms. Carbo were fit to own or carry firearms. Skylar Coleman knew both of those facts. Skylar Coleman knew from every infraction we just talked about that Drew Cantrell should never have even been able to hold the firearm or be employed at Shooting Star Gun Club. Now, Ms. Carbo came on the stand today. She explained that the email in person, and even a third time when she came to buy the gun, she explained her knowledgehood. She explained her want for a safety course. But she had to ask for that safety course herself, not once, but 2 times. But Dr. Morgan Judd explained that Ms. Carbo needed to ask for her own safety course, while Skylar Coleman knew she was unfit, was in direct violation of the law. Skylar Coleman was ready to let Ms. Carbo walk out of the gun shop without even knowing how to hold a gun. That is an accident waiting to happen. But tonight, I want to talk more about the defense's arguments, because they talked a lot about a liability waiver today. They said that because Miss Carbo signed this liability waiver, that she assumed the risk walking into that gun range. But I want to acknowledge the fact that before you're going to deliberate in this case, the judge is going to tell you that in the state of Imperion, the president states that despite the fact that one can sign a liability waiver, it does not mean they assume the risk in signing that liability waiver. The defense must prove to you that Ms. Carbo assumed the risk and they failed to do that tonight. Because you heard Ms. Carbo explain that she felt she had to sign a liability waiver. Because she would never have been able to take the gun safety course if she didn't. So the liability in this case still falls solely on Shooting Star Gun Club. Members of the jury, we all know how dangerous a gun is. It's not a toy, it's not a game, it's something that can take a life. Now, Ms. Carbo knew that, and in desperation for her safety, she chose Shooting Star Gun Club, a place she thought could protect and teach her, a place that ultimately failed her. Now, Skylar Coleman and Shooting Star knew they had a responsibility to keep their customers safe. And they had every chance to do so. They had a chance when deciding to hire Drew Cantrell, when deciding to retain Drew Cantrell after they violated gun safety rules and risked lives of others. They had a chance when selling Miss Carbo a firearm. But those are all chances they never took. And because of that choice by the defendant, accidents did happen. Miss Carbo getting shot happened. That is what we ask, that you find the defendant liable. Thank you.
Defense?
Sure. Your Honor, I have a concern that in the procedures of this trial, it against the rules have any sidebars.
For all disclosure, due to, she clearly has a sore throat, she just simply asked that someone else on her team take over, since speaking for 5-10 plus minutes would clearly put a strain on her throat, and they still have another round today, so,
Of course.
I have agreed that if someone else would like to take her place, they certainly can.
Your Honor. May it please the court, opposing counsel and members of the jury. At the outset of the trial, my colleague Sarah Curry told you about the risks and how Ms. Carbo knew the risks. Now we can see what she meant. Firstly, I'd like to address opposing counsel's argument in one sentence. It was mentioned that Cantrell was merely hired for her enthusiasm for money. However, opposing counsel failed to mention her qualifications. The government of Imperion deemed that the qualifications that Drew Cantrell had were all that were necessary for her to complete this trial. If it was necessary, if the government needed it, that's all that started needed. Ms. Carbo was fully aware of the risks on May 28, 2022, when she walked into Shooting Star Gun Club. Mrs. Carbo had never held a gun before, but she did know that firearms were dangerous. Members of the jury, the plaintiff told Kirby's legal team to sue my client, Shooting Star Gun Club, for negligence in their hiring, supervising, and retention of their employee, Drew Cantrell. This means that they took on a burden of proof to demonstrate the superiority of evidence that it is more likely than not that Drew Cantrell was unfit to give safety instruction course. Members of the jury, it is my argument that the opposing counsel have not met this standard. Let's address the first accusation regarding Drew Cantrell that she was inexperienced and incompetent to be a firearm safety instructor. Today we heard that Drew Cantrell had years of experience with guns. Drew Cantrell was initially hired as a sales clerk, and over the time they observed other instructors giving lessons, which is no better way to learn than on-the-job training, I would suggest.
Members of the jury, Drew Cantrell was not inexperienced with guns. She had a firearms certificate from the Imperial Department of Justice. Cantrell knew how to safely operate a gun and how to safely teach others. The second element of the plaintiff's case was Scarlett Coleman's knowledge of Drew Cantrell's experience. We heard from Scarlett Coleman that she made sure Cantrell had experience before hiring and ensuring Drew Cantrell knew about guns. Scarlett Coleman made sure that Cantrell had opportunities to observe other firearm safety instructors and to learn more about operating guns and teaching others. We're not here to change the past. We have been open about the fact that there were some issues over the years with Drew Cantrell, an emphasis on over the years. It is important to note that though Drew Cantrell messed up with the safety instructor, Scarlett Coleman did not ignore the problem. She addressed it head on and never repeated it, which is a testament to how well Scarlett Coleman handled the situation. It was addressed. The third aspect was that Drew Cantrell's retention as an employee in Shooting Star resulted directly in the interview of Justice Harwood. Remember, members of the jury were heard from Jackie Stahl in her expert opinion that she believes the gun was a problem in today's case. We also heard that Justice Harwood bumped into Drew Cantrell during their training course, and that this could have led to Justice Harwood. We also saw that under cross-examination, the expert witness, Dr. Morgan Judd, confirmed no bullets were fired during Drew Cantrell's previous incident and no personal incident. Members of the jury, there are too many possible likely factors of failure to lay the blame exclusively at the feet of the Shooting Star. They also heard that Justice Harwood knew the risks involved on leaving the premises of Shooting Star. We also heard that Justice Harwood continued with Shooting Star despite the risk. You will also recall that in our opening speech delivered by my co-counsel Sarah Perry, we brought forward an affirmative defense in this case. This means that we have to prove to you that, number one, Justice Harwood knew the risk. Number two, they proceeded anyway. The meaning of an affirmative defense is that even if you conclude that the plaintiff team met their burden of proof today, we have met ours, we still must find the Shooting Star club not liable. I think that we have satisfied our burden. You will recall that on the stand, Justice Harwood told us she was aware of the risk and signed a liability waiver that outlined the risk. Our clients did everything in their power to ensure Harwood knew the risk and knew what could happen in the government. Justice Harwood saw the signs. I am fully aware of the risks and hazards involved with being on the stand. As stated in paragraph 2 of the liability waiver. I also want to address the subject that was discussed earlier, that Ms. Coleman only promoted Drew Cantrell because it was good for her balance sheet. It's ironic that you heard that Justice Harwood told you they wanted every last penny from Shooting Star. I say that the only individual who was concerned with money in the case was Ms. Justice Harwood, disregarding the notices and warnings of the risk, solely focused on improving her own balance sheet. Members of the jury, Justice Harwood even signed the bottom of the waiver saying that they were aware of the risk. Ladies and gentlemen, we have proven today that Justice Harwood proceeded in the face of risk and not in being in a gun range, despite our client's best efforts warned. This is why they asked me, the jury, find Shooting Star club not liable, because they did everything in their power to keep Justice Harwood safe. Finally, I'd like to thank you, members of the jury, for your attention and time today. It is wholeheartedly appreciated. Thank you for listening.
Rebuttal? Yes, Your Honor.
Now, in their closing arguments, the defense stated, we're not here to change the past. And I can agree with that sentiment, because even if we wanted to change the past, even if we wanted to go back and not let Scarlett Coleman hire a person who wasn't fit to hold firearms, even if we wanted to go into the past and not let Scarlett Coleman promote a person who never taught safety course before, we couldn't. We couldn't go back and change the past. But here today in courts, we can find justice for the past. Because Justice Harwood was wronged. Because she is the victim of Shooting Star Gun Club's negligence.
Because when she signed that liability waiver, she may have known there were some risks, but she never knew that she was going to get shot by their safety instructor. Members of the jury, find Shooting Star Gun Club liable. Because while we can't change the past, while we can't stop accidents from happening, we can stop this from happening ever again. Thank you.
All right, that concludes the trial. We're gonna take a few minutes to finish our ballots. Please feel free to relax, take your shoes off, take your jackets off, breathe. And then we'll briefly give some comments once we finish.
Guys, it's so good.
Not like mine. Actually. I know. You're like. All right, I'm relax. We're not, do you need us to? All right, let us know what you need. Okay.
So they were not,
Yeah, I think it's easy.
Like on.
it means big heart.
I actually do love French.
Wait, Jared's post. And like. Because of I have a question for you.
Hey everyone, I'm just gonna do very brief comments. I know you guys are probably exhausted from yesterday and today. You still have one more round to go. And you're probably very hungry and want to have enough time to eat. So we're gonna keep it very general and pretty brief. second term, and we'll come back. So if you'd like to start, you can introduce yourself, let us know what you do, and then just general feedback.
Yeah. Hi, everyone. My name is Alana Lewis. I'm from Omaha, Nebraska, and I'm currently a 1L at the University of Chicago Law School. First off, phenomenal job by every single person here. You guys' ability to keep your composure during the trial was like 10 out of 10. I was just extremely impressed. I've watched like law students do similar things, and like you guys definitely could have convinced me you were actual attorneys. So phenomenal job there. In general, great understanding of courtroom procedure. I feel like you guys all definitely knew what you were talking about. You seem to have a good handling of the material. And again, in all, I would have believed you guys were real attorneys. So good job and good luck continuing in the competition. And yeah.
Yeah, I definitely echo everything she said. My name is Emily Hart. I am a almost newly licensed attorney. I recently graduated from the University of Chicago, Illinois, and took the bar in July, thankfully passed, and will be sworn in next week. Yeah, so I was a paralegal for a few years before I went to law school, and I did defense work. And now after going to law school, all through law school, and currently now I've done plaintiff's personal injury. So I've seen both sides. I know both sides. It's exactly the type of case that my firm would take on currently now, and this is stuff that I've done in the past. So it's great to see. You should all be very, very, very proud of yourselves. This is not a normal mock trial competition. This is a very elite level of mock trial, and you can definitely see it in your composure, your questions, your statements, your arguments. So you should all give yourselves a huge pat on the back, and all your teammates for being supportive and also working very hard to get here. Just general comments. The hardest part about mock trial is not getting up and remembering every line from your opening statement or remembering the next question. At this level of competition, I know you all know what your material is. You know the case, you can recite it inside and out. The hardest part about this competition, and if any of you decide to be attorneys, you'll learn that this is also still going to be the hardest part in the future, is thinking on your feet and responding to the unexpected. It will still rattle a 20+ year experienced attorney because they were thinking of that, objection. They weren't thinking of what was necessarily going to come out of the witness's mouth on cross-examination. So those surprises are really the defining factors in winning mock trial competitions and also winning trials in real life. It's extremely difficult, and it's even harder to practice because the only opportunity you really get to be under pressure in front of all these people are these types of competitions. And so to see all you guys respond and react to the objections or my rulings that may not have gone your way, I think just that in and of itself, you should be very proud of, because there's so many people in this world who cannot even fathom getting up in front of someone and giving a speech, nonetheless responding to an objection or a ruling that you completely disagree with and still maintaining composure. So I think you guys all did a very, very great job of responding on the spot of what was being thrown at you. And that's really what we're here to judge. I think the one piece of advice I would give you in terms of moving forward, and this is also just for mock trial in general, not just competition, is roadmap. We are all us three, the jurors and myself, what we like to probably consider ourselves smart individuals, but when we have this whole case being thrown at us, it's really easy to get kind of lost in what exactly is being said or what, the witness you're presenting is supposed to be, what element they're supposed to be fulfilling. So when you are creating either your direct, open, cross, anything, any examination or even opening statement or closing argument, dumbing it down for us, I know it sounds silly, but dumbing it down for us really helps us stay on track of what's going on. And it sounds so silly, but I think, I think you did a really nice job in your closing of saying, this is my first one. I think in the oral arguments, you did the same thing in the beginning motions. This is my first argument, and here's why. This is my second, and here's why. And even just that little cue, it makes me perk my ears and go, okay, so this witness is gonna give 3 opinions on these 3 subjects. That way, I can write them down and see, okay, did you say that? And okay, does this one opinion go to this element in your case or refute it? It helps us tremendously. And you guys did a really great job at shaving down, I'm sure, a lot of the extras in the case to get to where you guys are now. And just having that little bit of road mapping and directing your judge and your jury will not only, clarify things for you and clean up both your cases, but also will clarify things for us and will just make us understanding what your arguments are that much easier. But other than that, you guys did a phenomenal job. And I really wish you both the best of luck moving forward. You're the last.
My name is Ethan. I'm a 3rd-year undergraduate student also at the University of Chicago. I'm on trial team there. We got 5th national this year. And I'm gonna give, you guys are all fantastic. You know you're good. I'm gonna give a few actual things that you can implement, maybe for the next round or for the next competition. Starting off the first one, and I wrote this down on every single comment, was road mapping or signposting. I think that almost every direct examination and cross examination as well could just use more. And now let's talk about X, or I want to ask you about Y, or split it up into like 3 different points of the expert conclusion, or whatever it is. Just some of that road mapping helps the jury with not seeing it. The second point is on positioning. And I guess I was here before the round, sort of setting up. I think before the round, you can go with your team and agree on where you're going to do the direct examinations and where you're going to do the cross examinations, just so that it's uniform throughout all of those. So you'll do cross examinations like more towards the middle of the room, following the base of the jury, direct examinations. I think everyone's supposed to do direct examinations over on the side. Just make sure that that's standardized. That's something you can do with your team before the rounds. The third point for everyone is witness control. This depends, and different judges have different preferences, but I would be very hesitant of cutting off the witness when they're giving an answer. And this applies to both teams. You want to do more of like after they give the answer, that's not the one you want, you go redirecting you back to my question. Or so that's a yes to my question, or sometimes it's really egregious, that's not my question, and you re-ask it. But I'd be hesitant about cutting off or leaving a strike, just because the judge wants to see your like ability to rein in the witness without going to the additional mechanisms. Very quickly, on one comment for each side, in specific. For the P side, I think that the theme is good in the opening and the closing, but accidents waiting to happen, or it was accident waiting to happen. I think you can implement it into the direction possible. In a specific way is you keep on referring to the thing before the incidents, you should just call it accidents. That'll make it very clear as you're going along with it. Okay, this is going to be back to the theme, and that the accident going to happen is built on the previous accident because those are big of your case. And then for the defense side, at the end of the closing argument, I think you did a fantastic job explaining how assumption of risk plays into negligence case as an affirmative defense. I think this needs to come earlier as well in the opening. And throughout the direct examinations as well, explaining how exactly it interacts. Because for the judge, they might be confused about how it plays into the burden. And in this case, it's very beneficial to you. Even if you believe this states, or even if you believe the plaintiff has met their burden, assumption of risk basically that kicks in and then kicks out the duty aspect of it. So no, they no longer have a duty of care right to the client. If the client can assume their own risk. So I think establishing that very early on, and almost the first thing in the opening statement, will make it very clear when you're talking about the liability waiver. And the second thing is, I think you can get in a lot of the liability waiver stuff based off of one of two ways, either saying the signature is the client assuming the content of the documents, and then you can use the party opponent rule, because anything that Justice Carbo says or adopts, if it's an adopted statement, you can get in. Or maybe on the effect on the listener. I think you did make this argument that it's not about like the truth of the things on the liability, it's about what Justice Carbo says. So either one of those ways could be used to get the liability. But otherwise, great job and go eat lunch. Good luck with that.
I'll leave you with one little piece of hope. I was sitting where you guys were a long time ago. I did Empire back when it was only in New York. So if any of you are thinking like, man, this is really hard, but like, do I want to be a lawyer? Do I want to go through law school? Just know that all of this work that you're doing now is nothing but a benefit no matter what you do. And one day, if you decide to go to law school and be a lawyer, it's absolutely a possibility and something to look forward to. And I promise you these skills will transfer in whatever you do. And I really hope you guys are having fun this weekend. Because that's most important. Because I love that stuff. So best of luck.
Where we are.
Yeah.
So you can say that Justice Provost next year.
So I think.
Previous on up like me.
This is. Yes. This works in last
Now that's the ball.
Thank you, will need. So my movement in the hallway, they can come right here. One person, I think one person that come up here. Thank you. Thank Can I get everybody's attention? So this is gonna be a lot of moving pieces, so we're gonna have to keep our voices down, okay? I apologize. Thank you. Yes, yeah. 3, 2, 1. 3, 2, 1. All right, here we go. It's fairly right. All right, let's go. It's not. Joe? Can I get my first four? Actually, that's here we go. 3, 2. Ready in 5, 4, 3, 2, 1. Hold on.
I was like, no, I told him I couldn't go. I said, I think this is stopping.
What? You don't have to. Also, I see you. Go.
Three, two, one. Okay, okay, 3, 2, 1. Big smile. 3, 2, 1. Okay, and here we go. Yeah. Three, two, one. All right, let's do like this one or there we go. 2, 1. Right. Fun, let's have fun. Yeah, let me get you to come right here. Come on, man. All right, here we go. 3, 2. Yeah. Right, thank you, please. A little bit. Right. Yeah, I'm gonna take this. Take it. I'm sorry about this. All right, let's consolidate. Awesome. I don't see that. Well, let's get it. All right, big smile. I know y'all got it now. I don't even need to tell y'all what to do. Big smile. 3, 2, 1. All right, let's be serious. Arms folded. Arms folded. 3, 2, 1. Awesome. Let's have some fun with this thing. I know y'all got it. Come on. Take the phone. Take the phone. Nothing. Not monster. Great message. All right, here we go. 3. This. Hey, let's go. I'm gonna get them ready. And then here we go, y'all. Jerry. 3, 4, 5, 1. 3. 1. Maybe not what it really is. Improvement. Sounds right up. Y'all know about the code, right? Okay, there we go.
Wait, no, yourself.
I would love to have.
Two and three, one more, one, two.
Single feet. Let's go. Okay. Making my scene. We're going to. Yeah. Yeah, all right. Here. That here. Not crossing the road. Three, two, one. Let's go. The next one. Here we go. 3, 2, 1. 4, 1. 2. 7. Oh, wait. All right, good. 3, 2, 1. All right, here we go, here we go, here we go. Yeah, 10 minutes, everybody, so just to make sure we're ready, okay? All right, so we need to do this quick. All right. We need the back row. Here we go, here we go. 3, 2, oh, y'all, I'm now let's play a little more, right there, perfect. Here we go. 3, 2, 1. 3, 2, 1. Don't stop, don't stop. Hold on, here we go. Here we go. 3, 2, 1. Let's Ross, give me down. Here we go. 3, 2, 1. 4, 3, 2, 1. Captain. My coach is in the first half, but then I can just get y'all in the second half. Everybody can do it. We're gonna be serious. Serious. Here we go. 3, 2, 1. Smile, smile. 3, 2, 1. Awesome. One more smile. 3, 2, 1. Let me get my coaches out. Here we go. Smile. 3, 2, 1. Serious. 3, 2, 1. Awesome. Now run. 3, 2, 1. Yes, I'm sorry. Coming in six. I'm gonna look out right. $2.26. We got how many things on? Let's get in, let's get in. Here we go. Let me get that front row to kind of dip down just a little bit. All right, here we go. 3, 2, 1. Awesome. Let's get big smile. Big smile. 3, 2, 1. Awesome. Let's have fun. 3. Recording. 3, 2, 1. All right. See you quickly, quickly. Stop. Here we go. Hey, smile. Three, two, one. Let me get out of it. 3, 2, 1. Hey, let me get my next thing.
Lie down. Lie down. Right. And face.
Let me get scoot down.
Stop. Don't get up early.
All right, there we go. Here we go. No smiles. 3, 2, 1. Big smile. 3, 2, 1. Come on, I said big smile. 3, 2, 1. Let's have fun with it.
High energy, come on. All right.
Here we go. 3, 2, 1. Awesome. All right, here we go. All right. Y'all are up next. Y'all are on deck. All right, so if I can get in the photo with the kingdom, and then I'll have you step out. Quick.
All right, guys. Count of 3.
All right, here we go. 3, 2, 1.
I can't see you left. Can you drop down?
Because he was yelling.
Start with the purple. Start.
Yeah.
No,
All right, here we go. 3, 2, 1.
All right.
All right.
Okay, one more. 3, 2, 1. Awesome.
Can I get singing? Can I get singing?
I'm seeing this.
We have lots of.
Let me get my singing thing real quick. Real quick.
What about you?
All right, here we go. Go down a little bit. There we go. Hold on, come at the end. All right, here we go. Just unlet it. There you go. If y'all gonna do that. All right, here we go. 3, 2, 1. Let's have fun, seniors. 3, 2,
High energy.
3, 2, 1. Yeah.
Awesome. There we go. Now can I see you in the back of your heart? Right there. There we go. Here. There we go. We're good. Everyone's good. All right, serious face. No smiles. 1, 2, 3. One more. 1, 2, 3. Let's
Hold on, hold on. We're a little
We're off.
let me get one. Get you right here. Come up. There you go. Okay, I'm sorry. Yeah, man. Yeah. One time.
All right. Serious face.
All right, here we go.
2.
Hold on. Here.
Okay.
3, 2, 1. Awesome. Big smile. Big smile.
Big smile.
Now that's it. Here we go. 3, 2, smile. 3, 2, 1. Serious. One more time. All right, and let me get my coaches out. One more time. No smiles.
All right,
No
y'all.
smiles.
No smile.
Here we go. 3, 2, 1. Big smile. 3, 2, 1. Not yet. 3, 2, 1. All right, now you get on the table.
All right, yes. Right. It's your moment. Right.
So what is it on the other side? Lay down on the table.
All right.
Hold on. Let's go. Okay. Gotta turn that back in, so please no flag on. You got it? All right, here we go.
All right, there we go.
Look. Right here, bro. Look, right here. Right here. Here we go. All right, here we go, y'all. 3, 2, oh, can't see him?
Can't see.
Can't see, there you go.
All right,
No, people
can't see you. All right.
Let me get you still there, right here. Right here. Everybody. There you go, right there, there you go. Here we go. 3, 2, 1. 3, 2, 1. Now smile. 3, 2, 1. All right, we got this. Oh, we got singing. Go. 3, 2, 1. 3, 2, 1. Big smile. 3, 2, 1. All right, we need to get up real quick. Get up. Yeah, we're gonna do a serious one. Serious one. What am I saying? But it's not serious, it's more so like brother. Here we go. Last one. 3.
Lie down here, last one. There we go. All right.
Make sure.
I'll cut you.
All right.
All right, go. All right,
All right.
boy. All right. Three, two, one.
All right, we wrapped in here. Great job, everybody. We gotta put this room back. I don't know what they do. I think they need to on that. Yeah, they are. So. Yeah.
Right, I'm like.
No way. Your camera can't read the photo, like it won't go into a photo. So if I, if you were to hold that, you need help me? Yeah. Hi, Big John. Hey, oh. Why? The speakers don't work, they don't work. Now get out there. As long as you're happy, I'm happy. Who's that? Huh? I said, as long as you're happy, I'm happy for you. I hope that. Right? This, take a lot. Please.